Thank you for joining us for CSBA's Legal Update. I'm Elaine Yama-Garcia, Interim General Counsel at CSBA. In this video series, we bring you top attorneys in the state to weigh in on issues you could be facing at your district or your county office of education. Today we've brought together a panel of experts in special education law to discuss several areas that districts have been facing lately. The issues we will be covering in this series relate to educating special education students in the least restrictive environment versus mainstreaming students. We will discuss assessments and identification of students and how the Every Student Succeeds Act and the LCAP relate to assessments and programs for students with disabilities and students who may be struggling with other barriers that may be affecting their education. We will also discuss what has been contributing to the high cost of special education. But first, please allow me to introduce our panelists. We're glad to have with us today Ron Wenkart, General Counsel of Schools Legal Services at the Orange County Department of Education. Ron has been practicing in education for over 35 years. He has been that go-to attorney who is so knowledgeable at special education issues. I have always enjoyed listening to Ron's discussion. Unfortunately, Ron is retiring this summer, so having him here before he retires is very exciting. Welcome, Ron, and thank you for joining us.
Thank you.
Also joining us today is Sarah Sutherland. Sarah is a shareholder at Dennis Walliver Kelly in its San Diego office. Welcome back, Sarah. Great to have you here. Sarah is a member of the firm's Students and Special Education Practice Group. She represents students, well, she does represent schools, districts, and county offices of education and SELPAs in all issues involving students and charter schools. She focuses her practice in special education, student enrollment, and attendance rights, student discipline, foster, and homeless youth. She provides representation at administrative hearings and in the courts. And it's also with great pleasure I welcome to our panel Cynthia Vargas. Cynthia is a partner at Fagan, Friedman, and Fulfrost. Welcome, Cynthia, and thank you for joining us.
Thank you.
Cynthia works at her firm's Inland Empire and San Diego offices. She represents and advises school districts, county offices of education, and SELPAs statewide regarding all aspects of special education law. She advocates on behalf of public agencies in all capacities relating to mediations and administrative hearings, as well as handling complaints with the California Department of Education and investigations with the Office for Civil Rights. Prior to her career as an attorney, Cynthia worked as a special ed teacher, which is great to have practical understanding of education. So again, thank you, all of you, for joining us today at CSBA. I wanted to start out with talking about the recent U.S. Supreme Court decision, the last one that came out, Endrew F. And I wanted to kind of see if how that has been affecting, or if at all, affecting the decisions here in California. Ron, why don't you just start out with talking about that case? Let us know, remind us what it was.
Sure. Well, the Endrew F. case was decided by the Supreme Court last year, and they stated that the IDEA requires school districts to provide special education students with a level of benefits that is calculated to provide them with an appropriately ambitious program in light of their circumstances. And the Ninth Circuit previously, and we're in the Ninth Circuit, said that the standard was meaningful benefit. So it really wasn't a lot of change, but it was helpful when you look at providing a free, appropriate public education versus a least restrictive environment. It does provide us with some guidance, and it's a very helpful decision in helping us in individual cases.
How effective has it been at all, if at all, in California?
Well, I don't think it's made a major change. It's kind of reinforced what most school attorneys thought, that a de minimis benefit that some circuits had set as the standard would not be appropriate in the Ninth Circuit or in California, and that it really has to provide something more than de minimis. It has to be a meaningful benefit. And in light of the child's circumstances, is helpful because there's a whole range of special education students and their intellectual capacity and their cognitive level. So this is really very helpful. It specifically mentioned that you don't have to have a 1 year of progress for each year, each chronological year, 1 year of educational progress, which is helpful as well.
Great. So what is one of the key, what are the key special education issues out there right now that are being litigated in the courts or pending in the courts?
Well, I think one of the key issues is has to do with the least restrictive environment versus free appropriate public education. As I mentioned with the Endrew F case, we have to make sure that the child's making progress and receiving some benefit. And if the child's in a general education class, for example, and isn't receiving any benefit, then we may need to put them in a more supportive program with more services. And so that might, parents might object. We might get into a dispute with the parents over what is the least restrictive environment. But so the issue really is what takes precedence, free appropriate public education or least restrictive environment.
So how did if you haven't already asked this, but answered this, but how has the role of the lower courts and school officials, what is their role? Did that change at all in the Endrew F, or by the Endrew F case, or in any of the cases with regard to their role in the IEP process?
Well, I think the lower courts are trying to apply the Endrew F case, and there's a case pending in the Ninth Circuit now, RM versus Gilbert Unified School District out of Arizona, which in that case the school district recommended a more supportive placement for the student away from their neighborhood school, and the parents objected. They wanted the child at the neighborhood school, but the IEP team felt that the child wasn't making any progress and that the child would make meaningful progress in the more supportive program with additional services. And so the administrative law judge ruled in favor of the school district, the U.S. District Court ruled in favor of the school district, and now it's pending in the Ninth Circuit. The National School Boards Association and the Arizona School Boards Association are filing amicus briefs in the case in support of Gilbert Unified School District, and so we should have a decision in the near future. Hopefully the decision is in favor of the school district.
Okay, great. So when looking at the RM case, did the court look at any of the, when you look at least restrictive environment, is there precedent for that they're relying on?
Yes, there is a prior Ninth Circuit case called Pulaw versus Bishop, and there's also the Rachel H. case involving the Sacramento City Unified School District, where they said that the free appropriate public education takes precedence over least restrictive environment. And in the Rachel H. case, they look at, there's 4 factors that they look at. The main factor they look at, or the first factor, is the educational benefits of placement full-time in a regular class. And if the child's not benefiting from that instruction, then the child should be in a more supportive placement that has additional supports and additional services. And so I think that's what the U.S. District Court ruled in the case, and that's what NSBA and the Arizona School Boards Association are arguing as well, that the Ninth Circuit should affirm the U.S. District Court decision.
Did the case mention or is the Ninth Circuit looking at the roles of the parent in developing the child's IEP and choosing the placement?
They did say, and there's many cases that say that the parents are a key element in devising the IEP or developing the IEP, and that the parents' input should be considered. But also you need to consider the input of the educators involved, and the courts should not second guess the educators. They should defer to the education officials or the education experts. And as long as the education experts can articulate the reason for the recommendation that they made, then the courts should uphold what the education team is recommending.
Okay. Any other important issues that are coming out of that RM case that the Ninth Circuit is looking at right now?
I think that's the main case, the main issue that's coming out of that case is how do you balance the least restrictive environment versus free appropriate public education, and what deference do you give to educational administrators when they're making recommendations with respect to special education services and special education placement.
Okay, all right. Sarah, how has adoption of the Every Student Succeed Act changed or impacted compliance with the IDEA and the provision of educational benefit that Ron was speaking of before?
Yeah, I think it is yet to be seen what the actual impact will be, but ESSA is, I think, a very forward-looking, positive change to the federal policy from No Child Left Behind. It focuses, I think, a lot more on authentic, meaningful progress versus kind of the high-stakes testing under No Child Left Behind. As Ron was sharing with Endrew F, I thought Endrew F, the timing was interesting with ESSA and then also our state LCAP, because for years parent advocates, student advocates have been urging the Supreme Court to redo Rowley and to take up the Rowley case and to tell school districts that the some educational benefit is not enough and it's this dulled down standard. When you looked at the student in Rowley, she had gotten her high school diploma by the time the Supreme Court looked at it. She had graduated from college, and the issue was kind of what interpreter services she had gotten. And the Supreme Court said, no, you got the benefit the IDEA conferred on you because you earned a diploma, and we're going to assume the state has rigorous standards for all students. Fast forward 20 years, 30 years, and we get Endrew F., and that's a student whose disability was so severe that he was unable to participate in the regular education program at all. And we have a court that's interpreting it under these new education policy standards, and they really looked at it and they said, for this student, since he cannot participate in the regular program at all, the IEP really is his program, but for a very robust IEP, you cannot establish that you provided more than the de minimis benefit that Ron was referring to. And so I think that one of the things that ESSA reminded us of, which the IDEA requires, is that students should attend school where they would attend if non-disabled, unless the nature and severity of their needs requires another placement or program. And it's not about, that balance of least restrictive versus FAPE is, I think, more changing into a look at choice and what happens if, how do you make the place the parent chose appropriate, or do you move them to the place where the educators think would be more appropriate, more supportive? And I think there's a balance there, and that's what Rachel H. looked at, and I think we're still in that sort of balancing where there's more than one FAPE for every child, and where their parent chooses matters more so now than it ever did before, and the ESSA really, I think, continues that trend, as does the LCAB as well, and really giving local control so that kids can be educated where they would attend if non-disabled.
Yeah. Can you just give a quick background on the ESSA?
Yes, sure. So the ESSA is a federal law that was a reauthorization of No Child Left Behind. It was an interesting review for me because I was reminded that the federal government hadn't really touched education policy since the ESEA in the 60s, 70s.
Yeah.
So the Elementary and Secondary Education Act, which is what was reauthorized in No Child Left Behind, there was a huge, many decades gap, and then No Child Left Behind was, I don't want to say 10 years later, they did it again, which I think speaks volumes to how well thought out No Child Left Behind was, and the high stakes testing under No Child Left Behind really resulted in more segregation of students with disabilities and low performers, because it meant that for teachers, they didn't want students in their class that were struggling or that were not performing, and there was a lot more ability to put students on alternative curriculums, alternative assessments. So one of the things the ESSA did, for example, is create a 1% rule so that states are not to have students take alternative testing. The target is only 1% of students will be on alternative testing. So 99% of kids should take the CASP, which was very different under CSTs. We were nowhere near, I don't even think 90%, because there was not a rule, a target that we were going for with alternative assessments. Really, when the IDEA passed, it was this, and No Child Left Behind, it invigorated, they have to participate too, and they get to take these tests too. And then
their scores matter.
And their scores matter, exactly. Yeah. They too should be achieving the Rowley standard, the same, have access to the same curriculum content standards as their typically developing peers, and their special ed is to support them in that endeavor, not to be done kind of somewhere else.
Right, right. So what systems is the state putting into place to address these over-identification? Well, let me back up, because I think that with the ESSA and the identification or assessment of students with disabilities, but yet there are students with other barriers that are causing, educational issues with them, and that assessment of students at the initial identifying stage, it's almost a misidentification, and it becomes a disproportionate.
Correct. So one of the things that the IDEA did was adopt a disproportionality rule that required states to look at who's being identified based on race, English learner status, factors such as that. And at the end of the day, all students are really entitled to FAPE. Our Constitution entitles all students to FAPE, and the difference is that the students with disabilities have procedural safeguards and access to a judge in 45 days to challenge our provision of FAPE to them. And so that accountability piece is really what's present in special ed that's not present in the regular education program, and most of the state's efforts since passage of LCFF and the LCAP is on those efforts exactly. All of the things you do for students struggling with performance that's not disability related so that it doesn't become a disability.
Right.
The multi-tiered system of supports that is really based on a model of, and actually Orange County seemed to have some of the best models.
Yeah, Orange County Department of Education is taking the lead on MTSS.
Yeah, so I've watched a few videos that were very good, but MTSS it's this idea that we now know kids learn differently and we can't expect all students from diverse backgrounds, language, socioeconomic status, urban, rural, to all learn in the same way and to all value the same thing. And so to start with quality instruction and differentiated instruction that recognizes all students learn differently and we shouldn't expect all students to perform under the same conditions. And just because they don't doesn't mean they don't have the skill or can't have the skill. And so MTSS is based on kind of a idea of a quality regular education program that provides quality instruction for all students. It's differentiated based on their unique learning styles, their unique needs, whether it's learning English or being hungry, being homeless, being a foster student, any of the other target populations from the LCFF.
Yeah, interestingly, I mean, just like the balance between providing a child with FAPE and the least restrictive environment, you've got the MTSS, the differentiating instruction, coupled with, in the balance with that against, larger class sizes and the teachers, struggles with those types of things too. So it makes for an interesting development and changes in education that we're seeing.
Yeah, MTS is also going to focus on the socio-emotional needs of the students as well, so that they will be able to learn. So they're working, Orange County Department of Education received a grant from the state to develop programs statewide. So they're working with Butte County and a few other counties in partnership to develop programs.
Yeah, and
that's fantastic.
Great. The state just adopted in March, I think it was, SocialEmotional Guidelines.
Yes.
That are actually they're really wonderful. They're great. I've trained on them a couple of times, and the question is always, who's going to do this? Because it sounds very special ed-ish,
Yes.
It's all.
and where do the dollars come from?
Yes,
where do the dollars
exactly.
come from? Yes.
Yeah. But I do think it's this, at the end of the day, the IDEA, while environment is a rule-out factor, with things like specific learning disability and emotional disturbance, environment can disable you. And I think we have had to kind of move on from that concept of, this is a conduct issue versus a disability issue, because at the end of the day, the law doesn't exclude, they're not mutually exclusive of each other. And so because the IDEA has criteria that allows environment to really impact your achievement, I think really the new state systems are focused on really managing the regular ed environment in a way that their performance isn't so impacted that they need special education. And to address the needs. One of the videos I saw from Orange County really was very, I thought, well done in terms of, we're not talking about intervention, we're talking about quality instruction and quality program in school-wide systems so that all students learn, and really taking advantage of the environmental model that we have in public schools. Obviously we can't change, their parents, their home, how much resources they have in their family, but we can make them feel successful at school. And when a student feels successful at school, the barriers they can overcome in their lives is amazing.
Yeah.
And so that seems to be really what the state is focused on, is all those pre-referral, before we need intervention, ensuring that they are successful at school, and changing what we do versus changing what they do.
Yeah, which is great. I mean, I hope that it's that it's being accepted throughout the state. So it's great. So what about the adoption of the LCAP, and how has that affected or impacted the provision of special education and related services, if at all?
Yeah, well, I think it's a real useful tool for us, and we can do a better job of using it to build in our own accountability system, so we're not left with due process, which I know Cynthia will talk a lot about the cost of that, and it is incredibly expensive. And so you mentioned disproportionality, and I think this kind of goes to that, and I didn't finish that train of thought. So the federal government adopted a new disproportionality rule back in 2016 that was supposed to go into effect this summer, that looks at states monitoring identification of students by race primarily, recognizing that we have disproportionate identification of students by race. And just as an example, I think something that's a little less English learners in California, and 1 in 4 English learners are identified as disabled, and that's just not possible, that 25% of people learning English also have a disability. You know, there should only be about 10%.
It's not consistent with the rest of the state, right?
Correct, there should only be about 10%. And so under the new disproportionality rule, 60% of districts in California would be disproportionate, meaning they would have students either over-identified or disproportionately identified by race. And so with those sorts of numbers, the state has had to focus on putting systems in that are not special ed, because California has too long used special ed as the only system for addressing poor performance. And so for me, the LCAP is really our opportunity to build in local accountability for these other MTSS, PBIS, SST, so that when parents are unhappy about how their student is doing in an RTI program, they have maybe a hearing or some availability to challenge that at their board level, so that OAH, the Office of Administrative Hearings, and a due process complaint isn't their only realm. I'm constantly reminded that there are not parents that want to be at IEP meetings or desire to have disabled children. There are parents who have a struggling child who want them to do better. They want them to get more, and in California, more is special ed.
Yeah.
And so building more that is not special ed, I think, is very important. And then the accountability piece is what's entirely lacking.
Right.
And so it goes on for years, and then the parent files a child find case, and it turns into a special education issue when it maybe never was. And the parent is really just trying to get more, not necessarily make their child disabled.
Right. So you were talking about the interventions before. What other interventions, or what should school districts be looking at when looking at intervention programs for students with disabilities, and what are they considering that's out there right now? What is the state considering? What's the local level considering?
So the state's push, and Ron, feel free to chime in, please, on if you have more detailed information, but it's definitely on this. Well, just because I know Orange County is so involved in building all this, because the reality is that the state passed LCFF in 2013. For 2 years later, the federal government passed the ESSA, and we have now spent the better part of the last year developing our state plan, kind of backwards, versus, so if we had waited 2 years, we would have a much easier time complying with the federal law. But we already had, for example, our dashboard in place, and they don't like our dashboard. But so these MTSS systems that involve looking at first providing quality instruction and then providing intervention, but the key with the intervention is that it has to be targeted and based on data about that student. One of the issues we've had with the SST process, for example, which is of course a general ed intervention to monitor and guide referrals for special ed, is it's haphazard, it's troubleshooting, it's let's try this, give them extra time, give them extra work. But then the next year's teacher gets the student and they try another set of interventions.
Everybody does it differently.
Exactly.
Everybody does it differently, and there's not a good tracking system to track whether or not the child's making progress.
So they seem to be focused on creating systems that have teams of people reviewing data about students that are not identified and creating plans for them where they can monitor and guide further interventions, so that we're not just, we start with good instruction and then we move to intervention, but intervention that's targeted and based on data versus troubleshooting, which is what it's been to date.
Yeah.
And I think that's the idea behind the MTSS. They want to develop a system, a uniform system that's consistent and will help school districts identify kids, provide intervention if they need it, and avoid going to special education, to keep them in general education.
And I'll tell you, I hear too often, well, if I have a child who is wobbler, could qualify, may or may not qualify, districts are tending to find them eligible because there aren't good systems in place for them, and it's the one place that they can get some support, and that's what's creating this disproportionality. We're over-identifying our kids.
There needs to be systems in place, and I think MTSS will help.
Yes.
Ron, I don't know if we've it's a multi-tier support services?
System of support.
System of supports. And what is exactly, can you just briefly describe what
I'm certainly not an expert on it, so, so I'm not sure if I can really give a good description. It would be better if we had one of our instruction people do it. But it's designed to provide, like a multi-tiered system, so that you start out with good instruction, then you do intervention if necessary. That's kind of in a nutshell, and we really would need a curriculum person to really explain it well.
Okay. So Sarah, I know that you have you've been actually utilizing it with, and discussing it with some of your districts. What have they been seeing, and maybe talk about?
Right. So, you know, MTSS, it's based on a set of 10 core components, if you will, that start with quality instruction, differentiating instruction, universal design for learning, universal tools. I feel like we've gotten a lot more sophisticated in understanding that, for example, extra time doesn't make something easier. Everyone can use a calculator. Book on tape is not a big deal. You know, and so we've gotten, I think, a lot more flexible in terms of how we let students show us what they know versus having them do something under a certain...
Yeah, it doesn't have to be written out every single time.
Right,
anymore.
they can type it, that's
yes,
okay.
Yes.
So just from the definition, and the CDE's definition, the core components of MTSS are supposed to create this integrated framework. And so it's a system of supports that is then based on Common Core standards, core instruction for all students at high quality, and then differentiating learning and teaching before you up the interventions and start moving kids around, small groups, all those more RTI-based interventions. And so it really, the first part of it is to really ensure a very robust regular ed program that is implementing the Common Core in a way that is accessible to all students, whether they're learning English, whether they're foster youth, whether they're homeless, whether they're wonderful and have everything they need. You know, every child is going to learn a little differently, so differentiating that instruction. And then moving on to more restrictive. So it's not till the 10th component that we would look at disability and referring for special ed. It's number 10 is maybe they're disabled. So we got to get through 9 steps first, which shows us that that's, you know.
And interestingly, I mean, this is what special ed teachers do, right? They differentiate instruction, they individualize instruction, they try to break things down into smaller components, put children in smaller groups. So really realigning your training programs to where your general ed teachers are learning from your special education teachers on how to do these things, I think is going to be so valuable going forward, because your general education teachers have a way of teaching, and they can learn from each other. I think they can learn from each other.
Cynthia, so Sarah was discussing the over-identification of students in special ed. How is that contributing to the high costs of special ed that are already high, but the rising costs of special education?
Well, that has a direct impact, obviously, because if you have more children to serve, there's more cost involved, right? So historically, special education dollars were separated based upon the level of support a particular child received, and you got more dollars for a higher level of support, whereas now it's basically the funding is based strictly on your ADA, your average daily attendance. So you get the same amount of dollars regardless of how many students are in special education at this point in time. So obviously, the more children you have in special ed, the higher the cost is going to be with those things. So direct impact.
So in watching the development of special education costs and cases over the past several years, I have to think that the decisions have had a significant impact on the rising costs as well. What else is contributing to the cost of special education? What are those cases out there that what are they telling us?
You know, and it's funny, when you're talking about special education, it's really hard not to talk about costs, right? I mean, it's such a big impact. And I know that board members are wondering why is there such an encroachment from the special education into the general education fund, and why are we seeing so many settlement agreements coming across our desk? And it looks like the settlement agreements are going up in cost. And so really we just can't talk about special ed without talking about the cost of special ed. And so there are a number of cases that have had an impact on that, but in my opinion, there are 5 key decisions that have come out of the Ninth Circuit over the last few years that really have had a direct impact on the cost of special education. And I can't go into any of them very deeply, obviously. We don't have that much time. I would love to. I could talk about them all day long, all day. But I will briefly just kind of just give a quick little overview and then talk about how that trickles down into more cost, obviously, right? So in 2013, we had a decision come out of Tustin Unified, wherein at the OAH level, the Office of Administrative Hearing level, so the due process level, the district was found to have met all of its requirements under the IDEA. So so basically, we had a student who was deaf and hard of hearing, and that child their parents wanted additional supports for the child. The school district took the position that that wasn't necessary, and the parent filed for due process against the district, and the district prevailed. At the district court level, the parents appealed the decision to the district court, and at the district court level, they not only challenged the decision of the administrative law judge, but they also filed a complaint under Section 504. So remember, in the world of special ed, we have two different statutory authorities that we have to work under, right? We've got the IDEA, which is the Individuals with Disabilities in Education Act, and then we have Section 504, which is part of the Americans with Disabilities Act. And under those two provisions, there's actually two different requirements for providing FAPE. So we heard Ron talk about, FAPE and with the Endrew F decision, and they're talking about under the IDEA. And FAPE under the IDEA is very much about progress and monitoring progress and watching the progress that the child made. Under the Section 504, FAPE is more about equal access and whether or not we're providing a child equal access. Under the statutory authority of 504, there's language in there that says one of the ways to ensure that you're meeting your 504 requirements is by implementing the child's IEP, the Individual Education Program, which is what comes under the IDEA. So historically, we've always taken the position that if you've met your IDEA requirements, then 504 is met as well. Well, then we get this Tustin decision. The district court dismissed the Section 504 component of that case, saying, no, they met their IDEA requirements, therefore they met their 504 requirements. That was then appealed to the Ninth Circuit, who said, well, wait a minute, time out. FAPE under IDEA is different than FAPE under 504. And so, no, it's not necessarily the case that just because you met your IDEA requirements, that you also met your 504 requirements. That leads to discussions when we're in the world of settling a case and whether or not a parent's attorney is willing to resolve the 504 issues in the middle of those settlement discussions. So that just complicates things with regard to settlement. So that's Tustin. That was in 2013. And so we're seeing more cases where we're separating out those issues.
So what you're saying is that they litigate the IDEA issues through the IDEA due process. Correct. And then they also then can go into the courts and
do a completely separate case
504.
Under Section 504.
Okay.
So obviously, as attorneys representing school districts, we want to try to resolve all issues that include your ADA and your IDEA claims, and parents' attorneys are savvy. They know I don't have to, right? So that's what that's creating. So that's one thing that's led to cost. And then we have a statute in California that's unique to California that basically says that if a parent doesn't agree to an IEP, we are under the obligation to the services, supports and services offered in that program. Then in California, we're under an obligation to file for due process. And so that causes additional litigation in the world of special ed that you wouldn't see in other states. In other states, if a school district is, if a child's in special ed, school district, like in RM's situation, right? In RM's situation, they recognize that the program that that child was in is not appropriate to meet the child's needs, and so they made a recommendation to change the program. In any other state, once that recommendation was made, the school district sends out what's called a prior written notice, and then they implement the program. If the parent disputes the program, the parent has to file for due process. California, we have a statute that's different, and it's Education Code 56-346, and essentially it says that if the district believes the parts that the parent does not agree to are necessary for that child to benefit from their educational program, the district shall file for due process. So there's additional litigation that's required. And in 2015, we had a decision out of the Ninth Circuit that addressed that statute specifically. And the school district, LA Unified, was found to have denied FAPE because they let too much time go by before they filed for due process. The other three cases all came out last year. And they really had an impact, in my opinion, even more so than Tustin and the LA Unified case. One of those was the Antelope Valley case. And Antelope Valley is a case where a student had some vision therapy services, vision itinerant services, and an error was made in the child's IEP. It was a tactical error that it could be made for any of us, and who have sat through IEP meetings, and we've looked at those IEP documents. those errors happen. In fact, I think one of the gentlemen from our firm had looked it up, and there's like 810 different ways you can go wrong in drafting an IEP. 810 ways that you can.
I was going to say that.
Even more,
I bet
right?
it's more.
But he took the time to count it out. So in this case, the child received services weekly. They accidentally put it in as monthly. That was the big error. And ultimately, they had the other problem was they corrected the error, then didn't send a copy of that corrected IEP to the parent. Okay. So ultimately, the case goes through due process. It gets appealed to the district court, gets up to the Ninth Circuit. And the Ninth Circuit looks at that error and says, this is a big deal. And they felt that it was a big deal because in their mind, and it's true, I've said this for years, an IEP, an individual education program, is a contract. It is a contract between the parent and the school district. And the parent needs to be able to implement and enforce that contract. And so ultimately, the court held that little procedural errors such as that meant that the district could have at any time changed that child's services to reflect what they accidentally wrote in the IEP instead of what the parent was under the understanding that they were getting. And so the court essentially took the position that when procedural errors are made during an IEP team meeting, it's essentially a deprivation to the child. It is because parents are rarely represented at IEP team meetings by counsel. The court felt that any error like that results in a deprivation to the child. So,
very interesting part about that case. I don't know if you're going to mention this, but the parent found out in the due process hearing that this had happened,
right.
And I think that was very offensive to the judges.
It really bothered them.
It
They
really
actually
bothered them.
put a footnote in there ordering, because they kicked the case back down to the district court, and they ordered the court to determine whether or not it was intentional or accidental.
Exactly.
And if it was intentional, they wanted sufficiently severe sanctions against the school district.
Wow. Right, and so I felt like that was very important.
It was very important to and this is,
I feel like people are talking about that case and now typos deny FAPE, and typos don't deny FAPE if the parent knew.
Right.
And the issue there was that they corrected it surreptitiously and never informed the parent.
And never provided a copy.
And the parent then filed a complaint to challenge it, and then their defense was, oh, that's not what we're doing. And so,
and there was
I think it was less the typo than it was the parent's clear misunderstanding of what the school district was providing to her child, which deprived her of the ability to participate in it, consent to it, all those things.
The court found that very relevant, and so what it means now is you see school districts are much more cautious and careful, and it takes more time to develop them, and those small errors lead to bigger problems.
It really emphasizes the fact that you need to keep the parent informed, and it's really important
100%.
that you give the parent notice.
Right, yes. Right. And then there's REB versus Hawaii is another case. It was very similar, right along lines with Antelope Valley, and how important it is that things that are discussed by the IEP team are actually implemented into the IEP document, not just referred to in the notes of the IEP. So under the REB decision, the court felt that because the team had spoken about a particular methodology as being important for the child, that they needed to actually identify that in the IEP. That's very different than what we've had in the past. We've never put methodology in the IEP itself. It was intentional because school districts have the discretion to choose its methodology, to choose its personnel. But now we have the Ninth Circuit saying, oh, no. If you think it's necessary for the child, you must put it in there. So that was that decision.
There's so much that's necessary.
Exactly, I
so
know.
Yes. Oh my goodness, all right.
And then finally, actually, REB came out after the Avila decision, but Avila v. Spokane brings into question the statute of limitations issue and whether or not parents can go further than 2 years behind. Now, OAH, Office of Administrative Hearings, who does our administrative hearing level, the due process hearing level, is basically taking the position that Spokane doesn't necessarily apply in California. But Spokane is about whether or not a parent can go beyond, so there is a 2-year statute of limitations for special education cases, which generally means once a parent recognizes that there's a problem, they have 2 years to file for due process over that issue, creating a 2-year time period. And there's a couple of exceptions to that, but Spokane doesn't deal with the exceptions. But the language under the IDEA is slightly different than the language under California law. And OAH, Office of Administrative Hearings, thankfully, is taking a position that California language is significantly different enough that we're not following the Spokane rule. And we can go into that, but I know we don't have enough time to really go into all of those things. But none of those cases, as far as I know, have been challenged yet. That OAH now taking this position that we don't follow Spokane because we have Education Code 56505. None of those have been challenged yet to determine what will the Ninth Circuit see as far as the distinguishing differences in that language. It's a very minor difference between the language between the IDEA and the California Education Code. So how do all these cases lead to more costs for special ed, right? We've got all kinds of factors contributing to the increase in cost, disproportionality, the increase in wages and benefits and things like that. Those all contribute to more. But these cases specifically embolden parents, right? They embolden parents and parents' attorneys. And so what we're seeing are due process cases being filed that even though Office of Administrative Hearings is taking the position that the Spokane, Washington statute of limitations doesn't apply in California, I see cases being filed all the time where they're challenging the statute of limitations. They want to go back to the 2014-2015 school year, 2010. I had a filing this year where they went back to the 2011-12 school year. And interestingly, the Office of Administrative Hearings has taken the position that they cannot rule on those issues before the hearing, which means that you then have to prepare everything for the hearing as though you're going back as far as 2011. And then present evidence to determine where that statute of limitations actually cuts off. So the cost of cases are becoming more complicated.
That adds a tremendous cost when you have to go back that far. Because you know, you have to find witnesses, people take other jobs, they retire. You know, all kinds of things happen when you go back more than 2 years.
Even 2 years it can be difficult, right? Yes.
So it really adds to the cost and the amount of time that attorneys and the staff have to work on the case.
Yes, and right now with the fact that OAH, Office of Administrative Hearings, is not deciding those that statute, then we have to have hearing time, actual days of hearing where you're trying to determine just first and foremost where that statute of limitation cuts off. It really,
and that lengthens the hearing and increases the legal fees.
It does, incredibly, yes, and the time, and it's more that, you know, obviously the legal fees are more, but there's the time that teachers are out of class, and when teachers are out of class, you need to hire substitutes. They're not there working with their children, and so there's just so many more trickle-down costs involved too. And then with the Antelope Valley decision, you know, you've got a lot more, you know, Ron, are you still doing hearings? I don't know if you still do. So you're doing hearings, so both of you, Ron and Sarah. So you see, you know, I mean, you know, I've got one of my points here is lack of or the cost of additional training is a considerable factor too. This is adding to the cost because if we're not doing sufficient training for our staff, then they're under the impression that these small little procedural errors are not as critical as they once were. I mean, they're not as critical. They don't understand that. And so then when we get the file and it's time for us to, you know, a due process filing has been initiated, and so we get the file and we look at it and we have, you know, we see these little things where, you know, in Antelope Valley, it was about writing per month versus per week. Other things that we see on a regular basis is they'll check mark both individual and small group. Individual and small group, not specific enough for the parent. And if an IEP is a contract, the parent needs to be able to say, I get this many sessions at small group, my child does, or this many sessions of individualized. And teams don't understand the significance and the importance of those minor, small deficits, or maybe they didn't put enough information into the IEP. So we look at it and we think, we can't go forward with this hearing. Or you can, but you know, there are issues that are going to be ruled against the district. So Antelope Valley and the REB decision have a different kind of impact in that we really do need to provide more training to our teams to ensure they're ready.
As both Cynthia and Ron were saying too, the days of hearing really is what drives, is the primary driver of cost, because attorney time is the primary driver of due process hearing costs on both sides. But OEH we've seen them get more and more formal in their procedures as they've took over the contract, in 2005, I think it started.
2005.
And so they've now they've renewed the contract, and they're adopting regulations now to govern this process. And they are very focused on providing parents their day in court. And as you said, they are not willing to get rid of issues, even on the law. On motion, they want to let the parent take testimony. And so I just had a recent statute of limitation case, and we did 7 days just on the statute of limitations.
There you go. So what would have been
7
a 2
days,
to 4 day hearing is now an 11-day hearing.
Right, and then the actual due process hearing ended up being over 1 day of FAPE.
I was just going to say, that probably lasted longer than the actual merits of the issue.
It probably did,
That adds a tremendous cost.
It does, and so when we're sitting down with your directors of special education, with the the contact person that we're talking to, and we're talking about obviously there's plenty of times where the school districts did everything right. They did it right, especially substantively. I mean, we truly do understand that our teachers get into the business of teaching because they want to educate kids. They didn't do this to harm kids. They didn't know there was going to be all this legal stuff that they had to do, but they truly are in it to do the right thing, and in most cases they are doing the right thing. But when we sit down and we talk about, okay, so what is this going to look like? So then we get a due process filing where they're challenging the statute of limitations. So now we know that rather this being a 2 to 4 day hearing, we're looking at 10 to 11 days of hearing. The cost involved in that. And the fact that if you go to due process, it really only resolves the issues before OAH at that point in time. It may or may not resolve what could be an ADA-related case, and there could be other issues out there that the parent can actually still file on. They don't have to file on everything, and I've had those cases as well. So we're sitting down and we're talking about, okay, this case is likely to go to hearing, is going to cost you $50,000, $70,000 as an average cost, you know? And then it goes up from there, the more complicated it is compared to resolving it through a settlement agreement, perhaps, right? Through a settlement agreement, we always try to keep those costs lower than what it would cost to go to hearing. And through a settlement agreement, what we're really trying to do is make sure it waives all issues. Those that were before OAH for this one, any other IDEA-related issues, as well as your Section 504 issues. And so what I'm seeing, and I would imagine that our board members are seeing more and more settlement agreements coming across their desks. And they're asking themselves, why do we have so many cases? What are we doing wrong? What is our special ed team doing out there? And understand that parents and parents' attorneys are more emboldened. They're filing more. We're getting more due process filings. And those cases, those filings are becoming more and more complicated because of the decisions that are working their way down. And then there's all those costs involved in that litigation. And so when you see those settlement agreements coming through, you really do want to weigh that against, yes, I know we don't want to pay this particular attorney this amount of money, that meaning the opposing counsel, that's always part of a settlement agreement, but when you measure that against the cost of going to hearing, it's just a really difficult position for school districts to be in. And that's why you're seeing those cases come down.
It puts the special ed directors in
such a hot spot.
They become like claims adjusters. Yes, it's like an insurance claim. You got a claims adjuster and you look at what is the cost of settling versus actually going to hearing. And when the cost of going to a hearing is so high, that increases the level of the settlements too.
It does, because they know, opposing counsel knows, they know what it costs the school district to go to due process. And so they realize as long as I keep it enough under that number,
I'll never have to do the work.
Then I won't have to do the work.
And I will say this reality that Cynthia is talking about and Ron is referring to, it really has, I think, renewed this, we need to get back to a place where most of our special education students are objectively achieving state standards, because I have not ever had difficulty defending a student who's doing well in general ed classes. And so I think one of the issues with the special ed director and the special ed department getting all the heat for this is the reality is they are dealing with they're dealing with something that's become an issue, and a lot of the things the parent cares about and wants is not within their control and not in the program they control whatsoever. And so going back to how Ron started with Rowley and Endrew F. I mean, I think that the more, when a student is achieving the standards of their typically developing peers and passing their general education classes, we can almost always defend their IEP, and the mistakes don't matter. Right. The mistakes matter. The mistakes matter when it's the child's entire program and their progress is individual and not on par with typically developing peers. And so you can't assume it's good progress. You have to prove the progress is good for how severe their disability is. But like Ron said, it's less than a year's progress in a year. So you're an attorney sitting there saying, well, yeah, they didn't meet that goal, but they're just that disabled. Versus they didn't meet that goal, but they got an A in English 9. So,
you have to be able to articulate why this child, because of their cognitive level, why they can't achieve 1 year's progress in 1 year's time.
Which is tough.
It can be difficult.
But it's good that we have that language from Endrew F. We have something to sink our teeth in, because that's what the judges are always looking for. Well, what authority do you have on this issue? And so we have that language, but we have to convince this judge to understand, yes, for this child, that is appropriate progress.
That is appropriate progress.
And by the way, you know, forget about the fact that maybe there were a couple of procedural errors along the way, you know, but for this child, and so it's kind of easy for a judge to say, well, regardless of that, let's go back to the procedural errors. Because you know what, the kid's not making, is just not doing it. So let's rely on those procedural errors, find the district denied FAPE, and we don't really have to touch that whole, did they make enough progress or not, you know? And so that happens too.
Totally, and there's this huge disconnect, I think, between the judges. As much as they're not supposed to judge school district decisions in hindsight or progress in hindsight, this creates that, because what they're asking our school psychologists and our special ed teachers and our regular ed teachers to do is evaluate a child and say, you know, your child is so disabled, we don't think they're going to make a year's progress in a year. So even though they're going to go to 3rd grade next year, they're really only going to go to 2.3. But we're going to move them on to 3rd grade because that's good progress for them. And so it's almost like I've tried to think about how to have that conversation at the time. And, you know, our teams do not put caps on students' progress. They don't say,
they can't.
We only expect you to learn 2 months of information this year. But that's how judges are looking at it, which is, that's not how teams evaluate or make decisions.
And parent advocates too. Well, you just are not challenging them enough. These goals are not challenging enough. They need to be at grade level, and you've got a child who's functioning at a kindergarten level going into the 5th grade. They want to see goals that are written at a 5th grade standard, and you're trying to explain to this parent, I'm sorry, but your child's just never going to achieve that standard, or not in this short period of time. Right?
That's a very difficult thing to say to a parent.
It is very difficult.
Your child is so cognitively impaired that your child will not be able to make a year's progress in a year's time. And what that means is over time they'll fall farther and farther behind.
Exactly.
And that's difficult to tell a parent.
And you've got advocates telling them, oh, tell them to give you the support, and we want them to make not 1 year's progress, we want them to catch up. They get this impression that it's about catching up, you know, and so that too leads to further frustration with parents. You know, I like to tell school districts that, you know, especially for a unified school district, we may very well have this child from the time they're 3 until they're 22 years old. That's 19 years. Longer than most marriages in California, right? Longer than most marriages in California. And so that's a long time to be fighting with a parent. And they're feeling like you're not doing your job, and you know, it's such a difficult position for our teams. I mean, really just kudos to our special education teachers. Kudos to those program specialists who are out there trying to support, you know, their teams, and the special ed directors that are working as, you know, like you said, claims adjusters. That's a perfect description, really. You know, and so some of the other things that kind of the trickle-down costs would be, you know, you've got a lot more demanding parents. We have the internet, right? So parents can get access to almost everything, and some of them are more savvy than others. And so they're aware of these decisions that are coming out because they can find them on the internet. And they know that it's very expensive for school districts to go to due process, and they are more demanding. And they will do things like, we've got that education code that requires that in California, we have to file for due process, right? So if the parent doesn't sign an IEP, then the school district must file for due process. Parents know this now. And so, and the LA Unified case brought it to light, right? And so one of the things that we're seeing sometimes is they'll hold that signature hostage, right? And not provide consent. which then leads to teams maybe giving more than what that child would have normally got. Right, because we want to get that signature. That increases those costs. Absolutely.
Right.
More one-to-one aids, right?
Yeah.
Every child needs a one-to-one aid.
But that's what claims adjusters do in the insurance context.
Yes, they
want to settle
balance
because
that.
the litigation will cost more, so they'll give a little more.
Give a little more, and that leads to more cost. Forget
Yes.
about the actual dollars you're paying out to attorneys, but really just the more services we're providing because that the parents are becoming more and more demanding. So I just think there's so much to it.
The one cost I would add, I guess, that I think we haven't talked about is evaluation.
Oh, yes.
I was just going to say about assessing them and identifying them.
As I was kind of looking through my core components, listening to Cynthia talk about the cost, I was reminded that the third core component is data and evaluation. And even for our special education students, as much as we probably feel like we evaluate all the time, judges and parents do not feel that way.
They don't.
Right.
They don't. They think we should be doing it more.
Right.
Correct.
Yes.
And their answer to everything is evaluation, evaluation, evaluation. And as much as our teachers, special educators, regular educators are very well trained, and they typically can make a very educated guess that may or may not work, absent an assessment in a report that says that, we can't defend their opinion, their recommendation.
Right.
And so a lot of districts I worked with 10 years ago, they only would evaluate every 3 years, and otherwise would just work with the IEP team. And that is drastically changing, because as we go to more and more due process, you cannot defend yourself
if you don't
without
have a
high quality
assessment.
evaluations.
Yes. And,
Right.
and it needs to be a recent assessment.
Right, that's outside the statute of limitations.
Right.
And then in addition to the kind of that, and just the cost and honestly the availability of speech pathologists and school psychologists to do all these assessments.
The search for a speech pathologist, right?
Now we're
issue.
now we're being asked to do it in the regular ed program too, to evaluate students to get them from tier 1 to tier 2 and decide what tier 2 interventions they need prior to the tier 3 special ed evaluation, and what does that look like? And so I do think monitoring a lot of these costs are going to involve focusing significantly on the front end of your educational program and looking at not getting kids where they're 2 years behind and getting identified in third grade, fourth grade, fifth grade, if we could have prevented it
Interventions.
through interventions that were targeted through evaluation, data-driven team. These are all special ed words that we're using in non-special ed contexts.
Right.
So it'll be interesting to see how much litigation it will take to weed that out.
I know. And
which evaluation is when, if you evaluate to get between tier 1 and tier 2, is that a child find issue for tier 3?
Right.
And
child find, honestly,
a long time ago.
Yes, irregardless of all the cases that I mentioned, child find, that whole idea of when we should have assessed, when should we have triggered the knowledge that this child may have a disability. It's a very low threshold. That is, to me, the rising issue that I'm seeing more and more than anything.
Right.
That's a really tough issue.
It is
Very
a tough
difficult
issue. A child struggling at all, at what point do you assess them and the cost of those assessments?
At what point do you challenge or go to due process when the costs are so high at that point, right?
Right.
And then now you're assessing and you decide, so we just put them in special ed, or do we provide special ed services, or should we? That's a struggle for districts. That's a big struggle. So we need to wrap it up. And anybody else have anything else to say very quickly? Because we just have a few minutes.
I would just add that another issue with costs is that more and more kids are being identified with autism, as children with autism, and that's increasing the number of children in special education as well. And at the same time, the federal government is not keeping its promise in funding special education at the 40% level. And that's what's impacting state and local government, having to pay those additional costs.
As our numbers are going up with identifying children in special ed, the amount that's being funded through the federal government is going down. So if you look at the comparison between like 10 years ago and now, the feds were funding about 11% of the costs of special ed, and now it's down to about 8.6, 8.7%. So that the funds coming in are going down, and the number of children qualifying is going up.
So it's never been near the 40% level.
No.
They've never come
No,
close.
no.
10% or something was
Yes.
the best thing.
It's never come close.
So I guess I would also just like to, I think we're getting back to a place where special education is truly going to supplement the regular program, and it was originally designed to do that in the first place. And I think one of the things that's happened is we've kind of gotten away from that, and the statewide task force report recognizes that sort of silo that we have in the departments, and this is a special ed issue and this is a student issue. And I think the more we can get back to, these are all student issues, and some of them have special ed, some of them are foster youth, some of them are English learners, but to really think about kids as students first so that we can use the Common Core, LCAP, ESSA, to really get back to that model and use our LCAP, even though it's not currently required, to have goals related to MTSS, to have goals related to PBIS, to have goals related to preventing over-identification, preventing disproportionality, so that we build in those local accountability systems that are not there, that resulted in this kind of top-down, categorical accountability, due process hearing conundrum.
Yeah, that we're living in, this world that we're living in.
All right, well, our time is up. We want to thank our viewers for spending the last hour with us, as well as our presenters for your valuable insight. Ron, thanks for being here.
Thank you for inviting me.
Congratulations on your retirement again, your upcoming retirement. Sarah and Cynthia, we thank you for your firm's ongoing partnership with CSBA as business affiliates and for your contribution to today's discussion. You may contact our presenters if you have any questions via their email addresses that are posted here. Finally, this production would not be possible without the hard work of CSBA's communications, IT, business development, and legal teams. We welcome your suggestions for future topics, so if you have any great ideas, please email us at legal@csba.org. Thank you again for joining us today.